Well, hi, I'm John Deary, and we are delighted that you've taken a few minutes to view our face-to-face series in which we're talking attorney to attorney on topics now about medical malpractice, a very interesting one that many people have opinions about and think maybe they were impacted by. We have the attorney that we work in our office very closely with. He has a very interesting background. He was a doctor and now a very experienced and successful attorney, Eliot Wolf from the law firm of Wolf and Furman, and we're delighted to welcome Eliot to our series.
Thank you very much for that kind introduction, John.
Good. Medical malpractice, sometimes a misunderstood area of the law. So what's your definition?
Medical malpractice, to put it in simplest terms, is negligence by a doctor. The interesting thing is, in a malpractice trial, a jury is not told what malpractice is by the legal definition until the end of the trial, because they don't want you to jump to a conclusion. But in essence, a doctor has to use reasonable care in treating a patient. The reasonable care is the knowledge that he or she should have, and then they have to use it. So if they don't use that reasonable care, they're negligent. Just like a person who normally drives a car, if they don't drive it properly or reasonably, they're negligent.
I often hear the term deviation associated with malpractice. What does that mean?
Medicine has certain standards of care. The standards of care are the proper ways of treating patients. Unfortunately, most of the standards of care are not written down or codified. And as a result, the standards of care are open to opinion. But there are certain things that everybody would agree are a deviation or going away from the standard of care. For instance, a doctor not washing his hands before he does surgery, everyone would admit that that would be a deviation from the standard of care. A doctor not looking at an X-ray result or an MRI report, that would be a deviation or going away from what the normal standard or the normal level of care a patient could reasonably expect.
I suppose if someone has a malignancy, cancer, it would probably be fair to say in this general area, the Hospital of Sloan Kettering is probably considered, even on a worldwide basis and perhaps nationally, has at least a reputation as being, let's call it, one of the top hospitals dealing with that. Now, is that the standard of care that is required for example, a hospital that may be not as high a level of care as a Sloan Kettering, a local community hospital? Is that the same standard that is required of treatment?
No, actually, somebody who's being treated at Sloan Kettering or Mount Sinai or Columbia Presbyterian, those hospitals are held to a higher standard of care. They hold themselves out as specialty centers, as centers where you're given superior medical care. Well, if you're told you're getting superior medical care, you should. A hospital that's in rural Oklahoma, which has one physician running the emergency room, over a 12-hour period on the weekend, obviously will not be held to the same standard of care as Sloan Kettering or Columbia Presbyterian or Mount Sinai. On the other side of the coin, there is some universal standards, some universal levels of care that every patient going to a doctor or a hospital should expect and should reasonably expect to receive.
So often we hear people that feel, well, I was there with my dad, and when the surgeon came out, he really didn't spend very much time with me and kind of gave us some quick answers and then disappeared. So there tends to be, I think in this area, gee, I went to an emergency room and I wound up waiting 4 hours, 6 hours before I got some service. There seems to be in this area some confusion as to what is medical malpractice and the areas that are annoying but probably don't fit into the malpractice area. Has that been your experience?
I find a lot of prospective clients have issues with the way they were treated from a human point of view. And the interesting thing is, having been a physician and having taken risk management courses as a physician in order to lower the amount of times physicians get sued, one of the things physicians are told are the importance of the bedside manner, of the interactions with the patient. If one of the most common things that people want to sue for is a bad result after surgery. Well, if the doctor before surgery explained, listen, there's a 10% chance that even if everything is done right, you can end up with this bad result, and the patient ends up with that bad result, the patient, if they were properly instructed and educated by the physician beforehand, and that the physician treated them not like a number but as a human being, and told them as they progressed that they in fact fell subject and are suffering from the very possible complication he told them was possible, that physician probably will not get sued, and that patient will have understood going in why this was a possibility and why they don't have a basis for a lawsuit.
Talking about surgery, there is a term of informed consent. How do you deal with that as an attorney handling medical malpractice cases? And does it mean if a patient who is now anticipating tomorrow or in a week, they're going to have a particular surgical procedure, here, right here, just sign right here, and then something goes wrong that is in fact malpractice, does that informed consent signature eliminate any possibility of a person having a suit and going forward?
Signing a form authorizing the surgery, I find pretty much universally doctors don't spend the amount of time with patients that should be spent, and patients sign it without reading them more often than not. Signing that does not preclude or give up one's rights to bring a suit for lack of informed consent. But the law for lack of informed consent is very, very specific. If somebody wants to bring a lawsuit for lack of informed consent, it's not enough for them to say, well, I wasn't told this, and had I been told this, I would not have had surgery. The standard that a jury is asked to answer is the following. Would a reasonable person in the position of a patient, would they have agreed to undergo the surgery had they been fully instructed? A doctor has a duty to tell a patient, this surgery should work 90% of the time or almost all the time, but there are the following complications. And they don't have to tell you complications that are 1 in a million, but complications that are significant and have a chance of occurring that I would say is at least a 1% chance. If something has 20 different complications that have a 1 or 2% chance of occurring, I think a patient should be educated about that, because then there's a 20 or 30% chance or even more that the surgery will fail, and the position the patient will be in if and when the surgery fails. A patient should be instructed about that before they submit to a surgical procedure.
There are certain classifications, sort of in a general way, of what constitutes malpractice, and I'd be interested in your comments on each of them. One would be a misdiagnosis. What does that mean?
Okay. A misdiagnosis is obvious. What the word is saying is somebody makes a wrong diagnosis. And the law is very favorable for physicians, because malpractice, when it is defined under the law, it states if the doctor makes a diagnosis that's unreasonable, that is, if he does not use his or her best judgment. So if there's a judgment call between two diagnoses and the doctor chooses the wrong one, just because that doctor chose the wrong diagnosis and made a misdiagnosis, that might not be malpractice. But there are other questions that the lawyer would have to ask. If one diagnosis is relatively benign, relatively harmless, and the other one is harmful, then it's reasonable to expect the physician to rule out and to make sure that the patient doesn't have this diagnosis that's harmful to the patient, because not making that diagnosis will cause harm to the patient. So those misdiagnosis cases are important. There's a concept in medicine, which lawyers obviously have picked up on, called a differential diagnosis. So if a patient comes in and they have 3 symptoms, a doctor has to form a differential diagnosis. It could be A, B, C, D, or E. Now, if one of those diagnoses is a possible cancer, for instance, the doctor has to rule out the cancer before relying that it's something else, because not ruling out the cancer will cause grave bodily injury to a patient, and that's malpractice.
A second kind of general malpractice case is a failure to diagnose. How does that get distinguished from the misdiagnosis?
Well, in some there's a little bit of an overlap, other than if the doctor included in his or her differential diagnosis, in the possible diagnoses, what was not diagnosed, the failure to diagnose. If the doctor did not consider that possibility, and there was a reason to consider that possibility, then that is failure to diagnose is almost unjustifiable by the doctor, and then a person would have a very meritorious lawsuit to sue that physician.
The third has to do with the issue of a surgical procedure where the outcome is not what was expected, and perhaps some issue as to whether the surgical procedure was performed properly.
That is an area I think that I receive more phone calls and inquiries about than anything else. People do not understand, or are not educated to understand by their physician, that most surgical procedures have risk. They're not educated to know that most surgical procedures have alternatives as well. So there are some surgical procedures which should be reserved for more serious conditions than the ones that the patient has. But the patient doesn't know that there's a lesser surgical procedure available to them. If they undergo a more significant surgical procedure and have complications as a result, then that is something that could be actionable. A lot of patients have complications from surgery which are normal complications. Sometimes there's a failure to heal, sometimes an infection can occur, sometimes the results are less than optimal even in the absence of malpractice. And again, if patients are properly educated by their physician, they'll understand going in, there are these possibilities, this is what could happen to them if one of these possibilities actually occurs. If they have a complication, if a bone is broken and then has to heal again together, there can be what's called a non-union or a delayed union. There could be a malunion, where a non-union is if the bone doesn't heal. A delayed union if it doesn't heal in a normal time frame. A malunion is if it heals at an angle, and that can cause other problems as well. An infection could cause all sorts of injury to the bone and or soft tissues around, and can cause horrendous scarring. Some patients form keloids. The doctors should ascertain before they do surgery if a patient forms keloids, especially if there's a procedure that has alternatives that are non-surgical. So there are a whole plethora, a whole laundry list of different things that have to be looked into when there's a less than optimal result.
We're going to take a quick break, and we'll come right back to continue our second part of the conversation on medical malpractice with Eliot Wolf. We'll be right back. Stay to part two.